afternoon, everyone. For today's session, we have with us Mr. Ajinkya Kurdukar, sir. Sir has practical experience of working in the legal domain since 2011. His experience of working with law firms and individual advocates in the past has given him a rich and diverse exposure of litigation as well as non-litigation legal work. His educational qualifications include schooling from Yashodam High School and has completed his law degree from DS Law College. He currently works extensively in both litigation and non-litigation domains in Mumbai. While graduating in law, Sir is also a qualified company secretary and has completed his diploma in maritime laws, business laws, private equity, and professional certification in arbitration from renowned institutions. He is also a visiting faculty in the University of Mumbai since 2016 for corporate and insolvency laws. He has been a TEDx Unplugged speaker and was recently awarded Youth Inspiration of the Year 2019 Award for Excellence in Legal Services. Sir also manages operations of the firm in Mumbai and has also done professional certification in commercial arbitration from Indian Institute of Arbitration and Mediation. He has also conducted various online mediation workshops for students. It's a pleasure to have you with us, sir.
Okay. Hello, everyone. And first of all, thank you so much, NLC Madhyasthta, for this opportunity and allowing me to share my views on this topic. It's one of the most important topics, especially after the 2015 amendment and the kind of judicial orders we are getting, and the view taken by the Supreme Court in the recent cases from 2017 till all the way up to 2020. I think this is one of the most essential and one of the most impacting topics when it comes to arbitration. So we are going to discuss some points related to impartiality, independence, and neutrality of arbitrators. So we have a fair idea of what the arbitration proceeding is, and what is the intent, and what is the what are the laws and the provisions governing the arbitration process. But let's go to the root of what arbitration is, and what is it that that distinguishes arbitration from the typical judicial proceedings that we see in the court. So the first and the most important thing is the autonomy that the parties who are getting into the contract, they have. So they have an autonomy of everything, deciding the process of arbitration, deciding on the arbitrators, deciding on the way the evidence has to be taken. Everything that the process of arbitration requires can be decided by mutual consent between the two parties. So autonomy is one of the most essential features of arbitration. Now, when we talk about autonomy, it essentially means that we are giving them the power, we are giving them the authority to decide who can adjudge their issues, who can adjudge their disputes. Now, when such a power is given to the parties, it is equally important to regulate as to who cannot be a judge in a particular issue, who cannot be a person who is deciding on the disputes or the merits of the disputes. And that is why this provision comes into play. That is why it is extremely important to understand the implications of this concept. Now, that's why it goes to the root cause of the intent of the entire arbitration process. Now, when we talk about independence, impartiality, and neutrality, people often get confused between all these three terms, and it's very obvious because for a layman it may just sound the same. Hey, I'm impartial, I'm independent, and I'm neutral. So it may just appear to be something which is the same, but in the eyes of law, these three are different things, and they are positioned in a specific manner in the scheme of the act with a specific intent. Now that's what we are going to discuss in the subsequent part. Now, when we talk about independence, now what is independence? When we talk about the fact that an arbitrator to an arbitration proceeding should be an independent arbitrator. Now, this term independent we have heard in different domains. We've spoken about independent directors, independent auditors, independent umpire, independent director. The multiple occasions we've come across this term. What is this independent or independence? This means that there is absence of any dependence. Absence of dependence essentially means that the arbitrator who is appointed has nothing to gain from the process of arbitration. He is not expecting anything from the process of arbitration, and he is only discharging his duties for which he was appointed. He is only discharging his duties within the capacity that has been granted to him by both the parties under Section 7. That's all. He cannot go beyond those duties. He cannot go beyond the powers which he is being awarded. Now that is the reason why independence plays a major role. That he has nothing to gain from arbitration. The moment he has anything to gain from that arbitration, whether he's losing or he's winning on the basis of the result of the arbitration, he is not independent. That is the reason why we have to understand what independence is. So independence and impartiality are the hallmarks, the bedrock of a successful arbitration proceeding. Now it is often said that the arbitration is only as good as the arbitrators are. So that's why impartiality and independence have to be understood to the very to have to be understood because they go to the very core of the intent of arbitration. So independence is the absence of dependence, where the arbitrator has nothing to gain from the arbitration. Now moving on to impartiality. Now, impartiality is exclusive from independence. That is to say, an arbitrator can be impartial, but he cannot be, but without being independent. He can be independent without being impartial. When we talk about impartiality, we are talking about a process where he is allowing equal opportunities to both the parties to present their case, to express their case. There are various judicial rulings to this effect, but I'm really not willing to get into the deeper aspects of of these terms as to how the Supreme Court has interpreted, because it's a very common thing, to be very honest. It's a very simple thing to understand. It's not rocket science that we need to understand that this is impartiality, this is independence. Impartiality is when you are according equal opportunities to both the participating parties. You are giving equal opportunities to both the parties to express their case, to express the merit, to argue on the merits of the case. If you are being biased to one party, and if you're being, if you're not according equal opportunity to the other party naturally will go and appeal to the court that although the award was passed, but I was not heard properly. To avoid a situation like this, to avoid a constant intervention of the court in the process, independence and impartiality have been accorded a very important position in the arbitral proceedings. Now, when we talk about impartiality, we talk about biases. When we talk about biases, there are two kinds of biases that have been spoken about, that have been discussed extensively in terms of arbitration. One is the apparent bias. So something which is on the face of something which may subsequently become uh, a ground for challenging the award, and the second part is an actual bias. An actual bias is on the face of it, it is a bias that this person who is appointed as an arbitrator is going to be biased. Now, when we talk about an actual bias, what situations come to our mind? It is a situation where one of the parties is appointing one of their employees or one of their senior management or one of their directors as the arbitrator. So it's obvious that this arbitrator who's been appointed is going to be biased in favor of the appointing party because he's a part of that organization. Now, this is an actual bias, which is right in the face of it. But as against this, an apparent bias is a position where there is a possibility of a biased arbitrator, but that shall depend on his conduct. That shall depend on his behavior. That shall depend on his subsequent decisions or orders or how he conducts the entire proceeding. It is fairly safe to say that an actual bias is identified right in the beginning of arbitration. However, an apparent bias can be discovered on the basis of the conduct of the arbitrators. What is the position in Indian law? चलो impartiality, independence तो discuss हो गया, हम समझ गए कि independence एक चीज होती है, impartiality एक चीज होती है. दोनों एक साथ रह सकते हैं, दोनों अलग अलग भी रह सकते हैं. It can, as I said, it can be possible that I, as an arbitrator, I am not impartial to anyone, but boss, I am dependent. I am going to get something out of it. Possible position. There can be a position where I'm not getting anything out of it, but boss, I'm favoring this guy. Why? For whatever obvious reasons. And the point is that impartiality and independence both have to be tested right in the beginning or in the due course of the arbitration. This is something that we need to focus on, that we need to really put our minds to. When we are conducting arbitrations, whenever, as a counsel, if you're arguing, constantly you need to think that when an appointment is made, can you challenge that appointment? This is a very practical aspect that we are talking about. Challenging the appointment of an arbitrator is one of the most basic things that a counsel does. Why? Because there is either there is going to be an actual bias, or that he's not allowed to be an arbitrator in the first place. That's something that we are going to discuss subsequently, Schedule 7, once we start discussing the Indian law. So that's why it's pretty important. Now, moving on quickly to the legislative structure, the scheme that we have in front of us. So as I said, I would highly recommend the viewers to have their bare acts right in front of them, because this is something that we are going to discuss. We are going to discuss section 12, section 14, and we are going to discuss the schedule 5 and the schedule 7. So I suggest that it will be very, very helpful if you have the provisions in front of you. Now, before 2015, as we all know, as students of arbitration, the situation was, the game was played on entirely a different level. It was only after 2015 that we actually started following the UNCITRAL rules, that we actually started following the intent of what arbitration is, what the Act was established for. Now, 2015 and 2019 amendments are a different chapter and altogether. I mean, I will not be going into all of that, but 2015 amendment played a huge role when we discussed what the impartiality is, or when we discuss what the independence of arbitrators is. Now, I will just request my friends to open the BEAR Act, because it will be very helpful for them to quickly go through the words of the Act. I'll quickly go through it. So what we are going to focus on is section 12, subsection 1 and section 12, subsection 5. Other parts, of course, we will be touching upon, but our focus is going to be section 12, subsection 1. I repeat, section 12, subsection 1, and focusing on section 12, subsection 5. Now, reading section 12, subsection 1 is when a person is approached in connection with this possible appointment as an arbitrator, he shall disclose, highlighting the word disclose, in writing any circumstances. He shall disclose in writing any circumstances such as existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional. Understand, the scope of this subsection is very wide. First, past or present relationship with or interest in any of the parties. So when we talk about the relationship. Second, in relation to the subject matter in dispute, whether financial, business, professional, or any kind. So we talk about the subject matter. First was the relationship. Second was the subject matter, which is likely to give rise to justifiable. This is something which has always been a part of a lot of arguments in arbitration, which is likely to give rise to justifiable doubts as to his independence or impartiality. So anything that has to do with the relationship or the subject matter in dispute, that may give rise to justifiable doubts as to his independence or impartiality, is is the crux of section 12 subsection 1, and subclause B is which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the entire arbitration within the so on and so forth. The clause A is of extreme importance. So we need to understand one thing, that the scope of subsection 1 is extremely wide. Now, does that debar him? Does that debar him from becoming an arbitrator? The answer is in the negative. He is not debarred from becoming an arbitrator. He, in such a situation, if such conditions exist, wherein his relationship with the parties or the subject matter in the dispute may give justifiable doubts as to his independence or impartiality. Now, when we talk about whether he's debarred from becoming an arbitrator, we are talking about subsection 5. Moving on to subsection 5. Excuse me. Moving on to subsection 5. This was inserted after the amendment. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the disputes falls within any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. The difference between subsection 1 and subsection 5 is the essential difference between the 5th schedule and the 7th schedule. The first subsection, section 12, subsection 1, deals with justifiable doubts, whereas subsection 5 deals with ineligibility to be appointed as an arbitrator. Now, the natural graduation of this discussion will be ineligibility is counted right at the inception of arbitration, whereas justifiable doubts can occur during the process of arbitration, right? So we understand subsection 5 deals with the ineligibility. He is not eligible in the first place to be appointed as an arbitrator. In the subsection 1, he may be eligible, but may cause the parties to have justifiable doubts about his independence or impartiality. Now, moving on to another very practical aspect of this is, when you have any doubts about an arbitrator's independence or impartiality, you can use that ground. Understand, this is for all my friends who are practicing in arbitration. You can use those grounds to set aside the arbitral award under section 34. Use those grounds that because of these conditions, it created justifiable doubts as to his independence or impartiality, and therefore on these grounds, section 34 is triggered, and therefore the award should be set aside. Whereas in case of subsection 5, he is not eligible to become the arbitrator of the proceeding. Now, what the contents of the two schedules, schedule 5 and schedule 7 are, it's a long list. Honestly, I won't go into the verbatim discussion of the lists, but to give you a taste, a flavor of what is there in those schedules, it's a detailed list of the relationships that an arbitrator may have, which may give justifiable doubts as to his impartiality and independence. And the 7th schedule contains a little sort of a subset or a smaller list, which renders that arbitrator ineligible to be an arbitrator. So it's important that for all those people who are practicing arbitration, who are willing to get into arbitration, all those students who have interest in arbitration, it's important that you understand the entire schedule in its right sense. Spend some time, study that. It's a very simple schedule. Even if you read it 2-3 times, you will be able to get a hang of it. But that determines that those two schedules are the guiding principles for appointment and eligibility of arbitrators. And why is it important for you to study those two schedules so well? in advance, because those will be the grounds on which you can challenge the appointment or the proceeding of, or rather during the proceeding, you can challenge the independence and impartiality of the arbitrator. So moving on, I wanted to discuss two small case laws, rather very, I will touch upon those case laws, but they are very important. So I can share a note of these two case laws subsequently. In fact, Bhuvnesh, if you want, I can share my notes as for this topic subsequently if you want to share it with the students and the viewers. But
We can do that, so
Wastelpine GmbH versus Delhi Metro Rail Corporation. The name is German, so please pardon my incorrect pronunciations. But this case law is of high importance because it was observed that independence can be ascertained even before the proceedings commence, the arbitration proceedings. So that means when we spoke about independence previously, when we spoke about it, a couple of minutes ago, we did understand. Oh, not able to. Can you hear me, Bhuvnesh?
yes,
Are you
sir.
able to hear me?
Yes,
All
sir.
right,
Yes,
all
sir.
right. Okay. So when we discussed independence, we discussed that the independence can, the arbitrator can be a dependent one right from the inception, right from the beginning of the arbitration proceeding. That's what it was observed in this judgment, that independence can be ascertained even before the proceedings commence. Right. Second important case law that I would highly recommend the students to go through is the Saidi Corporation versus Gale India Limited. It's a very, very celebrated landmark judgment. Uh, I would want to read it out. The Supreme Court set out the difference in this case between the fifth schedule and the seventh schedule. The fifth schedule essentially is a broader list for the disclosures to be made by the arbitrator. The seventh schedule is a subset or a sub list determining the eligibility of the appointment of that arbitrator. Fifth schedule, as we discussed, is a broader list that controls the independence and the impartiality of the arbitrator, whereas the seventh schedule is a subset and a smaller list that determines the eligibility of the arbitrator. In case of the fifth schedule, the factors can only be challenged upon the award being made for setting aside of the award. In case of the seventh schedule, however, the challenge may be made during the proceedings, because we are challenging the eligibility of the arbitrator during the proceeding. So this distinguishing factor is very important for all of us to understand, that there is a difference between the schedule 5 and the schedule 7. There's a difference between justifiable doubts relating to the independence and impartiality and ineligibility. Right. So moving on, one important point I think that I missed was regarding the disclosure. Now, right at the inception, commencement of the arbitration proceedings, the arbitral tribunal is expected to give a disclosure. The process of how the disclosure is supposed to be given is already there in the act, which can be followed. The point is that it is all right at the inception. The arbitrator is expected to give a disclosure that, hey, I'm if I am falling under the schedule 5, anywhere in the schedule 5, I'm mentioning it, I'm already expressing it to you, and now it is up to you whether to continue with the arbitration proceeding or no. If the parties are okay with it, we go ahead. But if the parties deny, then the arbitration tribunal shall be reconstituted. Right. So the disclosure has to be given by the arbitrator, and I believe we've touched upon most part of the topic, most aspects of the topic. Um, See, honestly, there are multiple case laws in this for this topic which are relevant. I did not get really get too deep into it, because it's important that we understand the concept first of what Section 12 is, of what Section 13 gives the process, what Section 13 is, and what is the intent of the entire Arbitration Act, and how Section 12 is extremely relevant and forms the bedrock, or forms the one of the most essential pillars of arbitration proceedings. Once this concept is understood, and thereafter you can of course go through all the judicial pronouncements, judicial whatever the decisions of the Supreme Court have been, not just in India, elsewhere as well. I mean, in different other countries who are essentially the signatories to the New York Convention, have also held similar views, that with respect to the impartiality. Now, one last thing that I want to express, I want to discuss, is about what do other regulations, uh, let's say, how impartiality is discussed in terms of international arbitration. Now, we all know international arbitration, there are majority of them are institutional arbitrations, very few are in ad hoc arbitrations, but most of them are institutional arbitrations. Most of the institutional arbitrations, or most of the arbitration institutions which we have across the globe, they have their own guiding rule books, guiding set of rules, regulations, which contain specific provisions which deal with impartiality and independence. The IBA also has set of rules which deal with impartiality, neutrality. Neutrality is another very interesting topic that closely resembles impartiality, but has to deal with a lot of. It derives its meaning from the fact that an arbitrator who is appointed belongs to a particular nation. It is usually more relevant in terms of investment treaty arbitrations. So, yeah, I mean, most of the bylaws, or if I may say, the regulations of arbitration institutions contain specific provisions, specific rules regarding impartiality and disclosures, which need to be followed in terms of institutional arbitrations. I think I have touched upon most of the topics, most of the aspects of this topic, because although it's a small section, we are talking about just two sections and two schedules, but the impact of this concept, or impact of these two sections, is of wide importance, because it is important in two at two levels: A, during the arbitration proceeding, and it's B, it is very helpful in terms of challenging an award. So that's it from my end. So I'm definitely open for questions, Bhuvnesh and Sanya.
For explaining the concept so well and covering it very comprehensively. Now we'll move on to the Q&A. So the first question would be, why independence, impartiality, and neutrality play an important role in legal adjudication?
Okay, so I think we did deal with this right in the beginning. See, the basic point here is, in terms of regular courts, right? The judges are appointed by, in a particular process, following a particular process. But in terms of arbitration, the most unique aspect of arbitration is the parties are appointing the arbitrator. And that's where the entire game changes, because of the autonomy that the parties have. It is because we are looking at arbitration as a mechanism for resolving disputes, and if there is any partiality or any lack of independence, when we in terms of the arbitrators, it will it will collapse the entire machinery into nothing. It will destroy the purpose for which the arbitration act, or the process, the mechanism of arbitration, was initiated in the first place. So arbitration, during the arbitration, the impartiality and independence is like, it's like the bedrock of the entire process. So I think that should answer the question, because we are talking exclusively about the party autonomy, and that's where the independence comes into picture.
Thank you so much, sir. So, as we know that how independence and impartiality are important for any arbitral proceeding, and how they play a major role for not just for the parties, for even the process to be successful as such. So what are those behaviors that are viewed as a threat to independence and impartiality when it comes to arbitral proceedings?
Uh, See, that's a very, I mean, the answer is a very wide answer to this. Behavior aspect, we are essentially talking about during the proceedings. I will talk about, I mean, I'll share my practical experience. During the proceedings, the first and the most important thing that you should notice as far as the behavior of the arbitrator is concerned is the whether he or she is allowing both the parties to represent themselves correctly or not. It boils down to the fact that if one party is given less number of days to file their reply, and if the other party is given more opportunities, let's say, to amend their applications, these are very, very practical ways where you can determine whether there is partiality or impartiality in existence during the proceedings. I mean, I will not go into the bookish answers, to be very honest, but practically what you can look for during the arbitration proceeding is that if the arbitrator is kind of favoring one party ki yaar nahi हाँ तुम 10 दिन में you have to file the application, but 15 दिन हो गए, ठीक है चलो, no problem, I'll allow you. And if the other party has filed it on the 10th day, let's say at midnight, whether he's objecting to it. These are simple instances, these are simple uh, occasions where you witness that there is some sort of there is some sort of partiality, that the bias is in existence. That's one thing. Second thing is, it's also at times, just to give you a practical experience, share a practical experience, is that there are times where let's say one company is hiring. This is very rampant in construction arbitrations. One company is hiring a contractor, right? Now the contractor knows the nuances of the industry, of the construction industry, but the party hiring may not know the nuances of the construction industry, because unke liye to sirf mera construction complete ho, and that's sufficient for them. Now in such cases where certain terms, specific terms, are being used by the other party in a particular manner, where the arbitrator is aware about those terms, but the other party is not aware about those terms, whether the arbitrator is putting an effort to explain those terms and to to force the party to explain terms in a very simplified manner or no, also can be understood. You can also understand the partiality aspect from such small gestures. So as I said, independence and impartiality have to be uh, implied, or if they have to be understood on the basis of the behavior that the arbitrator has during the proceedings.
Thank you so much. Moving forward to the next question. When can the coercive powers of the courts be invoked to support arbitral proceedings already in process?
Okay, so yes, so the court can be approached on various occasions, to be honest, and when an ineligible, let's say, ineligible arbitrator is appointed as an arbitrator, you can take the help of the court. Or see, honestly, the courts in India are encouraging independent arbitration more and more. Okay? So, although in the Act there are certain provisions where you can take certain orders from the court, but of lately, at least in our experience, we have experienced that the courts are willing not to interfere in the course of arbitration, unless, when we read about the latest amendment, if you have gone through it, unless there is apparent fraud in the case, the arbitrator has been appointed with fraud, or there is some obvious fraud that is happening in the process, then of course, those are exceptional situations. But the courts are not very inclined to interfere in a smooth running process of arbitration. So unless there is something exceptionally wrong about arbitration, uh, you can invoke, of course, certain provisions of various sections of the Arbitration Act. But unless something extremely incorrect is happening, the courts will not really interfere as much as they used to prior to 2015. But now the courts have kind of taken a little backseat when it comes to interfering in arbitration proceedings. I think that's the correct way, because the courts are encouraging independent arbitrations and autonomous arbitrations. Because बार बार अगर courts interfere करेंगे तो फिर यार one person will go and take some stay or something, and then it spoils the whole purpose of arbitration.
Thank you so much, sir. So, sir, what according to you are the instances in which an arbitrator may be terminated from the arbitration proceeding?
Termination of arbitration. Okay, so termination of arbitrator is actually, it's a very clean process, because the section 14 deals with this process. So okay, the one interesting, to start with, to answer your question, section 14 deals with the entire scheme of events where the arbitrator can be terminated. But one important thing is that an arbitrator may be rendered ineligible de jure or de facto, right? So by the law he can be declared ineligible to be an arbitrator, or subsequently the arbitrator is incapable, as per the section schedule 7, he can be terminated, because the schedule very clearly mentions that these are the categories. If the arbitrator is falling in those categories, then he shall not be treated as an eligible arbitrator.
Next question would be, what are the major differences between the judicial impartiality and arbitral impartiality?
Okay, so impartiality is common, one thing for sure. In terms of arbitral impartiality, is something that has to be, that is on the shoulder of the parties, in my view, because it's the parties who are appointing the arbitrator, right? And in the due course, if they discover that there is some sort of partiality that is happening, the duty is on the shoulders of the parties to raise a voice and say that, hey, there is some partiality going on here, and that's why I do not think this arbitration proceeding is being conducted correctly. So they can use that ground in under section 34, where they can say that there was some sort of partiality, and they can express, and they can use that as a ground for setting aside the award. When we talk about judicial impartiality, honestly, the duty is on the judges to ensure that they are impartial. That's a part of their code of ethics, and that's a part of their duties towards adjudicating, as an adjudicating machinery. And subsequently also, the process of appointment is way different. When in terms of arbitration, we are talking about an appointment process which is conducted by the parties themselves. In terms of courts or judicial impartiality, however, the appointment is not on the basis of the parties. The appointment is done by some other process, following some other process. And the only duty that the parties have is to argue their case. That's the basic fundamental difference between judicial impartiality and impartiality in arbitration proceedings.
Thank you so much, sir. The next question is, how can international law tackle the concerns regarding the independence and the impartiality of investment treaty arbitration?
Okay. Okay, so see, when it comes to, that's a very interesting question, honestly. Investment treaty arbitration is something which is picking up. The discussions are you have these too many sessions happening about international treaty arbitration. So mainly, to be honest, Bhuvnesh, this particular issue is dealt with by two modes. One is when we talk about impartiality in terms of international investment treaty transactions, it is governed by the BITs, the bilateral treaties that we have. So the scope and the definitions of impartiality and ancillary provisions is already preset and predefined in those treaties. Additionally, also, it's important to know that when these arbitrations go to, let's say, an institution, and as we discussed previously, these institutions have their own set of bylaws, set of regulations that they follow, and in these regulations itself they have certain points, certain clauses which deal with impartiality. So that's a very interesting question, and how that is dealt, or what are those clauses like, I think it will require a separate session altogether on itself. But just to briefly answer your question, Bhuvnesh, it is dealt with by the fundamental clauses in the treaty, and or if it is absent, then certain regulations and certain clauses which are there in the bylaws or the regulations of the institution wherein the arbitration is conducted.
Thank you, sir. Moving forward, my next question would be, how are the independence and impartiality of the investment arbitrators currently regulated?
I think that was answered. I mean, it is largely connected to the previous question that we discussed. So it is, to reiterate, it is governed by the bylaws or the regulations of institutions that hold these arbitrations. It is also covered largely by the BITs or the treaties that are relied on for these arbitrations. So understand, it's more or less like the arbitration agreement that we have. So the agreement itself contains specific large detailed clauses which set the rules of the game for arbitration if there arises any dispute. So the bilateral treaties itself will be containing those clauses, and of course the institutions where these arbitrations happen, ICC hai, LSEI hai. So all these institutions also have their own regulations which deal with impartiality. So I think that's more or less it's in line with my previous answer.
Thank you so much, sir. So the next question is that what are the ethical duties that an arbitrator shall perform whilst an arbitration proceeding is in progress?
Ethical duties. Okay. First and foremost thing, a disclosure. I think that's the most important thing that an arbitrator should follow, because it's not purely ethical, it's also legal. Understand? Because if the provision expects the arbitrator to share that, the disclosure of any conflict, or if any ineligibility, or if any in case of impartiality or independence, he has to give out a disclosure right at the inception. Now, why is it a duty, and why is it an arbitrator's duty and not the party's duty? You understand, there are times where practically it's impossible for the parties to dig out information about that arbitrator. Today, almost anybody can be an arbitrator in a proceeding, right? There is no specific rule book, or there is no background check that happens with respect to an arbitrator's appointment. So therefore his independence has to be disclosed primarily by himself or herself, because uh, parties एक certain stage तक they can find out whether the arbitrator is impartial or independent or no. But it is, the duty is essentially casted on the shoulders of that arbitrator to disclose his independence. So that's why it's the first, and rather the most important, and rather I think the only duty that an arbitrator should follow, ethical duty that an arbitrator is subjected to, is with respect to the disclosure part. Second part, I think, in my experience, I would say that it will be with respect to the timeline that is followed, because again, one of the essential features of arbitration proceeding is the timely disposal, and he should stick to the timelines which are as per the act. And if he should not, basically not keep adjourning the matter again and again for baseless reasons and stuff like that. So I think, yeah, these two are the most important aspects when we talk about the ethics of an arbitrator. So the first is the disclosure part, and second is adhering to the timelines. Hello.
Thank you so much, sir. So the last question for today's session would be, can an arbitration be fast-tracked?
Yes, I think it can be fast tracked if if the arbitrators really adhere to and stick to the timelines which are mentioned in the Act and the amendments, and if the parties are very proactive in submission of the statement of defenses and applications and everything. Because see, at the end of it, it is all about the parties, the conduct of the parties. If they are proactive, I mean, we have been a part of arbitrations which were concluded in a remarkable short duration, because the parties were very quick, no adjournments, no unnecessary delays, and the arbitrator, of course, was also very proactive, and he hardly used to adjourn any matters. So in such cases, yes, the arbitration can be fast tracked, and as I said, it is the autonomy of the parties. So it largely depends on the conduct, how the parties perform, and how the arbitrator also gets himself involved in the process.
Thank you so much, sir, for gracing this session with your knowledge, experience, and guidance on the topic of impartiality and independence ethics of arbitrators. I'm sure students will be greatly benefited from the interactive session. Next, to place on record my special thanks to our principal in charge of Bharati Vidyapeeth, Dean to University, College, Pune, Dr. Bhagashri Deshpande ma'am, for her constant support and guidance. A big thanks to the management team of our college and our university, and a heartfelt thanks to all the students participating in today's session. Thank you, everyone.